Suspended Public Protector Advocate Busiswe Mkhwebane has given President Cyril Ramaphosa, the National Assembly Speaker Nosiviwe Mapisa-Nqakula, and the Committee Chairperson of the Section 194 inquiry until Thursday afternoon to respond to her letters. Mkhwebane has raised concern about the continuation of the committee's meetings in the absence of her legal team. Now, this comes after the acting Public Protector informed Mkhwebane that the office will no longer be able to foot the bill for her legal team as they have run out of funds. Newzroom Afrika's Athi Mtongana is following developments around this, and she's standing by to bring us the very latest. Good afternoon, Athi.
A very good afternoon to Dudu. I'm joined by the chairperson of the Section 194 Committee, Qubudile Dyantyi. Thank you so much for joining us. Now, there is a letter that the Public Protector has written to the President, the Speaker, and yourself. Perhaps let's start there.
Well, I don't know what you want about the letter, but we will consider the letter later when we're done with what we're busy doing now. And the important thing about what you're saying, so we received this letter yesterday, just 10 minutes before 10, when we start. I obviously would not have looked at that because I'm prepared to start the meeting. And 16 minutes after 11, a corrected version is sent. So apparently after things have been moderated by Twitter about the dates and all of that, the letter sets a deadline for tomorrow. We'll talk about that later before I close this meeting.
Now, some of the concerns that the suspended Public Protector has raised is the continuation of the committee meetings and the inclusion of the evidence leaders when you pointed out that this is a meeting for the members of the committee.
Yes, and I repeat that the committee has the right to have its own sessions. We have stepped off from the inquiry and sought to have, since Monday, today is the third day, where we're taking the members through the bulk of the evidence that has been presented so far over 6 days, over 2 charges, CR17, as well as the so-called rogue unit matters. And what we're doing is there's nothing wrong about it because we're empowered by our own terms of reference and the directives that we've created in the terms of reference, the evidence leaders as a support measure to the committee. We would have discussed 3 options before, whether we needed just a member-led process or we needed a process where it would have just expert leading, or thirdly, whether we could go for a hybrid. We chose the hybrid with the evidence leaders. So their role is clearly defined, that they have a role to empower and assist the members to make sense of the merits of any evidence placed in front of them. We would have done this even at any other time to allow them to do that. So, but what we're doing, there are 2 people who are benefiting out of that. The members are benefiting from this process, as well as the Public Protector.
She feels that she's been treated unfairly because you're dealing with evidence that could also be rebutted. For example, had she been part of the meeting or even with her legal team present. I think here one of the other issues that was raised by some of the committee members is then, why don't you take this to Parliament's legal services? Because the evidence leaders are not committee members, but they're actually dealing with some of the testimony that she has provided herself before the committee.
Yes, that ground was covered. Legal services clarified on the day, that afternoon, about the fact that we're within our rights and that there's nothing illegal about what we're doing. But I was just saying, the Public Protector is benefiting from this being an inquisitorial process, which is not accusatory. She now knows what type of questions are going to be asked from her, and then she can prepare based on just what is being presented here. And so the process itself is empowering and helping to her. But at the same time, there is no right that has been taken away from the Public Protector. She, in fact, is going to have an opportunity to respond to these issues at a time when the evidence leaders lead questions to her, and as well as when the members do. But he's got now more time to prepare to answer what has been placed, to say, here is a gap. As they are doing, when we come with a public protector would like these issues to be elaborated further, these questions to be asked. So there can't be anything that is said to be prejudicing her.
Now, my last question to you, Chair, is a lot of people are asking where to from now after that letter from the acting public protector informing the suspended public protector that they've run out of funds and that they can no longer foot the bill for her legal team, Advocate Dalimbofu and his team the other day, saying that's it from them, and the public protector on the other hand saying she does not have money. So now I guess the question around a lot of South Africans' minds is where to from now, what's going to happen? Will she come back before the inquiry? Will the hearings continue? What shape will they take following the fact that there are no funds to pay her legal team?
Well, where we need to start is that by Monday, in fact by Friday the 31st, it would have been 30 days when a notice would have been given to the public protector by their PPSA to say end of March we do not have money. And she was asked to start negotiations and other issues. By Friday it was clear nothing would have happened. I would have indicated on Friday that there are relevant role players that were going to edge on to assist and play their role, whether it is the Minister of Finance or Minister of Justice, the PPSA themselves. We're not involved in that. Our task is to conduct the inquiry. And the only thing we can play is to facilitate that happens. But may I also add and say, the Concord has been very clear that she must be given legal representative. But nowhere does it say that who must pay that legal representative. She could easily have gone to the legal aid to ask for those kind of resources, which is a state institution.
All right, I think we'll leave it there for now as you begin to continue chairing the second session of the committee, which is hearing from the evidence leaders around some of the judgments that came out from the courts in relation to the investigations that were done by the Office of the Public Protector, and in this case, the CR17 campaign. Dudu?
Thank you very much, Athi Mtongana. We'll have more news for you in a few moments. We speak to the